Okay, as I indicated, basically, I'm the interim general counsel, I should say, for the West Virginia Ethics Commission, and I wanted to take a look at some of the topics we're going to be handling today. The first one, one of the most important, obviously, is what does the Ethics Commission handle? Then we're going to do a survey of the West Virginia Ethics Act, and that will comprise most of the presentation. But we will also survey the West Virginia Open Meetings Act, some of the requirements it has basically as well toward the end of the presentation. First off, what does the West Virginia Ethics Commission handle? Well, of course, we give interpretations and give people advice about the West Virginia Ethics Act. We also can respond to inquiries about whether people are eligible to serve on county boards of education. We also give advice about the applicability of 61-10-15, which is a criminal statute that is closely related to parts of the West Virginia Ethics Act. We also take care of complaints and interpretations about the Administrative Law Judge Code of Conduct, and I might add that usually should be considered state administrative law judges. We also handle lobbyist registration, and we receive and keep a record of financial disclosure statements that are made by various public officials. And of course, as I said, we do handle the Open Meetings Act as far as interpreting it. With regard to enforcing it, that's something that's lodged by the legislature with the circuit courts of the counties where the governing bodies meet. First, the Ethics Act. The basic principle behind the Ethics Act is a prohibition against public officials or public employees using their public office for private gain. And I've just indicated there what it is. There is that prohibition. I might add that there is a de minimis exception. In other words, if you accidentally take away one of the company or one of the state agencies' pens or pencils in your pocket and use it at home, that would be considered de minimis. But and for those of you who are attorneys, you'll probably, your next question is ask, well, what's the bright line definition of what's de minimis and what's not? Unfortunately, there is no bright line definition. Basically, the commission tries to decide that on a case-by-case basis. And this is an indication of that. Obviously, there's some point to taking one roll of toilet paper from the bathroom may not be anything other than a de minimis use of public resources. Taking a whole case probably would be. Here's an example of a situation where an individual misused their public office. An administrator at a county board of education high school was a P card holder, and this individual utilized that P card to charge approximately $550 of material that was to be used for her wedding. She received a public reprimand for that infraction and also a $2,000 fine. The Ethics Act also extends to things like using bonus points from purchases you make for your agency. The statute's a little bit peculiar there. There are some exceptions. For example, business travel-related bonus or award points for airline tickets, hotel stays on business purposes, gasoline for travel are considered okay. The employer or the public official can keep those bonus points. On the other, and that's because there's a particular section of the Ethics Act that exempts that from the general prohibition. Other types of bonus points, for example, reward points for merchandise purchased from an online catalog or from brick and mortar stores, those bonus points are considered to be the property of the agency, and the individual employees or public officials cannot use them for their own personal purposes. Here's an interesting one that kind of opened my eyes a little bit. An agency may not allow its employees to do more than de minimis amount of use of an agency-provided cell phone as their personal cell phone, unless the employee pays a reasonable fee to the agency for that use. And this is true even if the agency has an unlimited data plan, in which case, obviously any additional use wouldn't cost the agency any more money. And whether there's a agreement and a reasonable fee paid by the employer or not, any commercial or political campaign use of these agency cell phones is absolutely forbidden. Next topic we want to talk about is nepotism. And my slides aren't cooperating with me. There we are. Nepotism. A public official or a public employee may not directly supervise their relatives or be involved in decisions affecting them. Now, that sounds kind of widespread, basically, but essentially, first thing you need to know is that the definition of relative for the purposes of the Ethics Act is a little more restrictive than most of us West Virginians think. For example, relatives mean, as it indicates there, spouse, mother, father, sister, brother, son, daughter, grandmother, grandfather, grandchild, mother-in-law, etc. It doesn't include first cousins, doesn't include uncles, doesn't include ex-spouses, although it would include someone that you reside with, whether you're married or not. This prohibition doesn't prevent people who are married to each other or are relatives or even immediate family from working together. The key is there can't be a supervisor-subordinate role. In this advisory opinion from 2023, a prosecutor asked if he could hire a couple, basically, to work as his assistant prosecutors. And the answer was, yes, you can, just so long as one of them doesn't supervise the other one or have any other kind of role in deciding the working conditions in terms of employment of their spouse. Next topic I'd like to speak about is unauthorized spending. In other words, using public resources, not necessarily for private gain, but basically for something that the agency isn't supposed to be using the money for. Now, the Ethics Commission itself has pretty limited involvement in determining whether a proposed expenditure is authorized or not. We rely on things like, of course, the West Virginia Code, legislative rules, Attorney General's opinions, auditors' opinions, and attorneys' opinions of various sorts, city charter or municipal code, things of that nature. All right. Let me turn off my phone here, which I forgot to do that. Okay. Given that, the fact that we have very little power or authority to determine whether something's unauthorized spending or not, you may wonder why we are addressing the topic and why we're even concerned with it. Well, it's because there's a little bit of tension in the Ethics Act. The Ethics Act prohibits public officials, and public employees, not only from using their position for their own benefit, but they can't use it for the private gain of another individual. In contrast to that, a public official or public employee is not using their office or employment for private gain if they're performing what is considered their usual and customary duties without any additional compensation. And whether an action or a agent spending money on a particular subject is authorized or not often kind of provides the tipping point between what would be considered usual and customary duties on one hand and using your office to benefit your friend or a particular person. So that's why we address that topic. Here's some examples of the kind of things, pretty obvious, I guess, that you can't use public funds for, like giving a public official a trip to Myrtle Beach or making a political contribution to a campaign. A big question we get a lot, usually toward Christmas time, is can public money be spent for employee recognition or retirement events? And we include in that things like Christmas parties and things like that. Here is the rule. Basically, food, beverages, entertainment, and gifts or small mementos, some amount of public resources can be used. How much there is, in this case, a kind of a bright line. You take the number of employees that the agency has, you multiply that by $25, and that gives you a figure. That figure is the maximum you can use for any and all employee recognition or retirement events, gifts, or something during a calendar year. You don't have to spend the same amount of money for each employee. You can allocate it among various employees. I guess those who are retiring would come in to have some priority. But there is a limit of the maximum that you can spend upon a particular employee for any kind of memento or gift of $100 per employee. Example of that, that $100 limit would apply to for something like plaques or things like that, some kind of retirement gift, something or other of that nature. Next area is endorsements. I'm sure most of you understand that public employees and public officials can't just go out and endorse businesses willy-nilly. But there's some little pitfalls that you have to be aware of. Endorsing commercial products would not necessarily require you to get on a billboard or to go on a TV commercial or radio ad supporting that commercial product. A lot of businesses send surveys, customer satisfaction surveys to all their customers, including their customers who are public agencies or governmental entities. You have to be careful there. You can't put down that you're a satisfied customer or that you recommend that people work with that particular business. In other words, it's probably a pretty good idea to just explain to anybody who sends you one of these surveys with those, friendly titles like "How did we do?" or "Did we do a good job serving you?" or whatever, and just say we can't do that. That would amount to a public endorsement. Could it get us into difficulties? Another area that relates to endorsement is being even-handed. For example, in an advisory opinion from 2021, a college professor asked if it would be possible for him, this individual taught a political science class at one of the universities, whether or not he may be able to invite a candidate to come and speak to his class for educational purposes, of course. And the Ethics Commission determined that that's possible, but you have to also give this individual, the candidate, their opponents, other people running for that office, this same opportunity to come and speak to the class. Otherwise, it will be viewed as an endorsement of that particular candidate. And using your public job or your public employment as a college professor to do that is not permissible. Here's another example. In this case, we refer to it usually as the coffee cup advisory opinion, also from 2021. A town employee had a cup that displayed a candidate for an office. It wasn't one who was up for election at that particular time, but had that on a mug that they had in their office. And someone asked, I don't remember whether that person or one of their co-employees or their supervisor, I asked if that was permissible. Could they have a cup with a candidate for a political office, used at the office? The commission determined in that situation that basically the person could use the cup, but it couldn't be used or observed by the public. In other words, if this person worked at a window where they serve customers, they could use the cup, but they had to turn it so that the people who come in to conduct business at the public office would not be able to see the name or the picture of the candidate that the cup endorsed, essentially. Another area, disclosure of confidential information. West Virginia Code 6B-2-5 subsection E indicates that a public official or a public employee who comes into some confidential information as a result of their position cannot disclose that to the public. It's not only a violation of the Ethics Act, but it's also one of the parts of the Ethics Act that has repercussions in criminal law. It can be a misdemeanor. And it's one of the few areas where doing something that doesn't benefit yourself or benefits a friend or family member or something is important. With regard to disclosing confidential information, it is a violation even if nobody benefits from it. And of course, what is confidential? We've given some examples there in this slide. Again, that's something that that other laws or other regulations determine whether it's confidential or not. We just apply those definitions. Gifts. We have these questions quite frequently, mostly along the lines, and I'm not talking about here of a gift from a co-employer or something, but receiving gifts, basically. Is something that a public official or a public employee must turn down if they can accept them? Are there any restrictions? Well, there are. The restrictions apply if you have a gift being given or offered to you from someone who is an interested person. An interested person would be, for example, with the case of the legislature, a lobbyist, or it may be anyone who is seeking or does business with the public servant, the employer, or the official's agency or a governmental entity. It can be from someone who is regulated or controlled by the agency, or if the individual or business has a specific financial interest which may substantially be affected by the performance or non-performance of the official duties. If any of those definitions or tags apply to a person, then you are limited in what kind of gifts you may accept from them. In fact, what you can accept, you can accept meals and beverages of any value if the person who's purchasing them is present. In other words, somebody can take you out to lunch, but they can't give you a $50 gift certificate to Outback or some other restaurant. Ceremonial gifts of insignificant values, as a plaque or a trophy or the key to the city or something like that's okay. And gifts that are purely private in nature. An example of that would be if your mother happens to be an interested person or qualifies an interested person who does business with your agency, but your mother always gets you a birthday gift, you can go ahead and accept a birthday gift from your mother or one of your other relatives or something along those lines. And before I go to solicitation of gifts, I'll mention to you that a gift below $25 in value is considered to be de minimis. So even if a person's an interested person and they give you a gift that's valued under $25, it's okay. But that's limit of $25 is a gift from that particular person or business for an entire calendar year. They can't give you a gift worth $23 on January the 1st, and then give you another gift for $23 in July, and then another gift for $23 worth in November. Those gifts would all be totaled up since they come within the same calendar year, and as a consequence, that would exceed the $25 limit. Now we just talked about acceptance of gifts. Now we're going to go to the other side of the coin and talk about solicitation of gifts. In general, that is just forbidden for public officials or public employees as part of their job. The only time that it isn't prohibited is if you are making a solicitation for a charitable purpose that doesn't benefit yourself or your co-employees or the official of your organization. And even then, if it's for charitable purposes, there are rules that must be followed. Going to those rules, skip past that one. The rules for solicitation of charitable purposes: no oral solicitation. In other words, you can't call somebody up. It needs to be in writing. You can't contact or target particular businesses or individuals that do business with your agency. If you make a general written solicitation, for example, if you're a city councilman and you solicit for some worthy charitable cause and you send one to every business in the town or every person in the town, that's fine, even if that includes some of the people that do business with the city. But they can't, those people who do business with the city or are regulated by the city cannot be targeted. You can also not solicit charitable contributions from your subordinates. And any solicitation in written form that you make must make it clear that the contribution is purely voluntary and no special treatment will be accorded to those who either give money to the charity or decline to give money to the charity. Now, an example of a charitable cause in an advisory opinion from 2021, it was held that a mayor could appear on a video using his name and his public title to promote and solicit donations for a local nonprofit drug and alcohol recovery center because that was considered to be a charitable cause. In general, the definition of charitable cause that the commission applies is what you would expect. Things like United Way, Red Cross, things that have a charitable purpose, food pantries, things of that, and some things that aren't designed specifically to aid the poor and the disadvantaged, but are for the general public good, kind of fall under that charitable donation or charitable cause exception. And this is another example, by the way, of a charitable cause. The city was held that they could solicit donations for their free outdoor concert series. And in that particular advisory opinion, it was suggested that a very good way to go about that solicitation without, while staying within the rules, within the regulations, were GoFundMe and other similar crowd-sourced fundings mechanisms, basically. Next, we go to public officials' name or likeness. Again, that's another section. There are restrictions. Public officials or agents or anyone on a public payroll may not put the public official's name or likeness on trinkets that are paid for by public funds or using public funds to distribute or hand out these trinkets. Now, I want to make clear here, we're talking about using public money. I don't know if county commissioner in a county wants to use their own money to buy calendars or pencils or some other trinket, keychains or something, use their own money to do it, they can put their name on it and all those things, and it's not a problem. What we're talking about is the name and likeness restrictions are documents and other things that are paid for by public money, the agency's money. There are, of course, exceptions, things like letterheads, envelopes, educational material, reports, announcements, things of that nature. Public officials' name or likeness can be placed on those items. I would note here, this isn't something covered by the Ethics Act, but I think it's interesting, and that is that we have a law that prohibits state, county, and municipal entities from dedicating or naming any public building or public structure for a public official who is currently holding office. That's just something that's outlawed. Now, prohibited contracts and their exceptions. The general rule is stated as follows. Public officials and employees may not have a financial interest in a public contract under their direct authority or their control. Of those two items, authority is pretty easy. Like, for example, a city paving contract is under the direct authority of the mayor and the city council members who vote to either, hire a company to pave their roads or not. Control is a little more difficult. Control over an agency's decision to enter a contract can result from a variety of factors as opposed to just simply who has the last word and who can approve the contract. If an individual, whether they be an official or an employee, instigate the contract, in other words, they bring the fact that we need new computers or we need to pave the road or something like that. In other words, they bring the issue up and push it. If they have close involvement in the ultimate decision, in other words, if whoever approves the contract relies upon a particular person for advice and explain to them the ins and outs of the situation, that would give that person a measure of control, and therefore they wouldn't be able to have a pecuniary or financial interest in that contract. Another one, supervision or oversight of the contract. The individual in question knows, or it's obvious that once the contract goes into effect, that this person will be the one who sees it going into effect. Either inspects the work or deals with the situation or the material that's being purchased or so forth. And there are a variety of advisory opinions on that. The key thing to remember is if you have involvement in the decision-making process, even if you don't have the final word, you may have control and there may be a prohibition against you having an interest in the contract. Now, Here's something that I want to make clear. It doesn't really fit into this section, but since it involves a contract, I think it does. And that is elected city officials may actually be employees of the city for which they're official. In other words, you can be a city council person or city councilman, and you can also be the I don't know, the water board or the water company, the municipal water company supervisor, or somebody who drives the truck that picks up the trash, or works on the roads, things of that nature. You can do both. Yeah, there are some voting restrictions. Obviously, if you work for the city, there are times when your working terms and conditions come before the, say, for example, a city council for a vote, and you would have to recuse yourself, because even though you're not prohibited from having an employment contract with the city, apart from your being a city council person, you can't just go and vote to give yourself a raise or something along those lines. With regard to prohibited contracts, there are some exceptions. There's a $1,000 threshold per year, and there's also exception for part-time appointed officials and legislators, and they're not subject to these general prohibitions. Ethics Commission has discretion to grant an exemption to a public entity based upon undue hardship or excessive cost. A good example of this, there was a situation where a county commission used a towing company they had a contract with them, and one of the county's vehicles, maintenance vehicles or other vehicles, had mechanical problems. This towing company would be called, and they'd come and pick up the vehicle, and and I guess they worked it out so they'd have a better price than if they just called somebody out of the blue. Unfortunately, the owner of this towing company got elected to the county commission, and the question was, can we still work with this towing company? After all, they're the only one in our county. And with some restrictions, the commission did grant an employment exemption for that county, to continue to do business with the towing company, even though a county commissioner was the owner of that towing company. Voting. In addition to prohibiting certain contracts, there are occasions when the contract itself isn't prohibited or the other action isn't prohibited, but an individual public official is required to recuse himself from voting. And we're going to talk about those rules a little bit now. An official may not vote if he or she, the public official, or an immediate family member, we're talking about spouses and people who reside with you, or a business with which they or an immediate family member is associated. And associated could mean that you own it or you work for it or something along those lines. If you have an interest like that, you may not vote on it. You may not also, if one of your relatives happens to work for the public or governmental entity that you're a public official for, you can't vote on personnel matters that involve that particular relative in a specific way. In those cases, you have to recuse yourself. Now, I want to make clear here, recusal means a little more than abstention. And abstention just means you decline to vote. If you recuse yourself on an issue, that means that you get up and leave the room and don't take part in the discussion or the vote. With regard to whether you have to recuse yourself, there's a class exception. In other words, if, for example, if you're, I don't know, your son works for the city and you're a city council person, and the question is, are we going to give all of our employees a 5% raise? And it happens that the city employs 25 or 30 people, in other words, 5 or more people, and your son wouldn't be affected in this manner any more than any of the other 24 to 29 employees of the city. In that case, you would not have to recuse yourself. That's called the class exception. Kind of tricky to apply sometimes too, but that's something for me to worry about and not you guys. I just told you a little bit about what recusal requires. As I say, and as the slide indicates, it's a little more than just abstention. Just got a question about voting restrictions. I'll try to answer that now. The person, if they recuse themselves, they should leave the room during the discussion, and they should stay out of the room until the voting is complete. In other words, they can't just leave the room while they're discussing it and then come back in and see who votes. And you may wonder why we have a rule like that. I guess the idea is if a person is in the room when the vote occurs, they might have an effect upon their fellow city council members or fellow county board of education members. If somebody who has an interest is there and with their arms folded like this and glaring at their fellow board members, it might affect how they vote. So in answer to the question we got about whether you could, when you recuse yourself, whether you can come back in the room before the voting is complete, no, you should not. You should stay out of the room, not only during the discussion, but till the voting is completed and the body moves to the next area or next item on the agenda. Now, we're going to talk now a little bit about employment restrictions, and we're talking both about employment descriptions, having a secondary job while you continue to work as a public employee or serve as a public official, as well as some restrictions that apply after you leave your public employment or leave your office as a public official. First, let's talk about the secondary jobs. Full-time public employees may not seek employment or actually do any sort of business at all, like buying or selling or leasing property, from any person who had a matter on which the public employee took some sort of regulatory action, or a situation or person where the public employee's subordinate took regulatory action within the last 12 months. Or anyone who any business or person who currently has a matter before their agency in which the public employee is working, or a subordinate is currently working on. They also may not seek a job or do any business with someone who happens to be a vendor of the agency if that public employee has any control over the contract with that vendor. And I think we talked a little while ago about how control goes beyond just having the final word about whether a contract is approved or not. There are public employment exemptions available. In other words, you can ask the Ethics Commission whether a proposed secondary job that you have or want to take or want to apply for, whether it is in fact something that's compatible, that you can continue public employment and work for this other business or person. Usually that doesn't come up with secondary employment. It usually comes up when somebody's planning to leave their public employment and they want to apply for a job for after they leave, but they want to start looking for the job before they quit, which I've always thought was a good idea, that if you're going to find a new job, you should find it before you quit. But in any event, there are some guidelines with regard to what you can and what you need to do if you want to go ahead and continue to work for the public, but seek a private job somewhere else. And there's also guidelines related to having a secondary or moonlighting, basically. You'll find both of those on our websites. The one on this Second Jobs in the Ethics Act is pretty new. It's only been up there about a year. Here are a couple of advisory opinions where people have asked whether they can continue to work in this particular private industry or for a particular law firm while serving in a public office. I won't read those to you, but you can see them there basically. Vendors, we've already talked a little bit about what control over contracts are. As far as control over contracts and vendors, in addition to those factors described, the statute itself applies a bunch of new elements that you must consider, like someone who drafted the bid specifications are put out for the vendor to bid on to try to get the job. And you can go ahead and read the slide, like I say, and anybody who's interested in a copy of this presentation, email me or put it in basically in the chat, and I'll be sure to send you a copy of it. Like I say, we don't copyright these things. And looks like we've got another question in our chat. Let me go to that. Our county health department's covered under the Open Meetings Act They are. If they are a county governmental organization, I believe that most of those county health departments are, and I believe they are covered by OMA. I've certainly answered Ethics Act and OMA questions from various county health departments. And the questioner goes on, if so, must the health department give notice to the public if the department wants to have a meeting with legislators? Well, if it is, we'll talk a little bit about that toward the end of our presentation. But for right now, I'll just indicate if it's a meeting with legislators where the members of the health department are not going to be talking about issues that will require or deliberating toward a decision on issues that they will have to take a vote on later on, then it doesn't meet the definition of meeting. And so just a meet and greet with the legislatures where they talk to the legislators about their problem, but really don't discuss among themselves what kind of action they're going to take as a health department. That probably would not meet the definition of meeting, and it probably would not require a notice, an agenda, and making that particular get together open to the public. But like I said, we'll talk a little more about that when we get to the Opens Meetings Act. Representation. And now we're going to post-employment restrictions. We're not talking about moonlighting or a second job, but I have left public employment and I am now working for somebody else. Is there any restriction on what I can do? Well, you may not represent a private party in a matter after you leave if you had worked on that particular matter involving that specific party, and if you had personally and substantially participated on behalf of the agency in a decision-making, advisory, or staff support capacity. So in other words, if you worked on the situation or represented the agency in a situation, you can't switch sides when you leave the agency and go to work for that private party. Of course, if it's a different matter, that's okay. And obviously the former agency can consent to that or waive that and allow you to go ahead and represent that business in that area. Revolving door. The revolving door only applies to certain public officials and certain public employees. Elected or appointed public officials are included. Full-time staff attorneys like myself, accountants, shall not, for 1 year after termination of their service, represent a client before the entity or board that they served in contested administrative matters, in support or to oppose a proposed rule, any sort of rate-making proceedings, and so forth. Which means, for example, if I were to up and quit the Ethics Commission or stop being an employee of theirs, for a 1 year period, I could not come and represent somebody who's got an ethics complaint against them and try to convince the Ethics Commission not to find probable cause and not to charge them or find them guilty. After that 1 year, I guess it would be okay unless it was a matter that I or a subordinate of mine worked for. Other people, and this is peculiar too, by the way, administrative law judges, for example, even though they are, for the most part, attorneys, they're not staff attorneys. This revolving door provision doesn't apply to them. Another area altogether, one of my least favorite because I don't work with it as much, and that's financial disclosure statements. Certain officials have to file a financial disclosure statement in February, and February 1st is the deadline. This year, I think February 1st falls on a Saturday, so I don't know whether the statute makes it clear or not, but from the Ethics Commission standpoint, if the first falls on a Saturday, you've got till the next business day, which would be Monday the 3rd, to file your financial disclosure statement. And I might add, if you're being pressed for being able to do that, if there's good cause shown, you can contact us and request an extension, and we're usually pretty decent about that for a reasonable extension, especially if there's a pretty good purpose behind it. The people that must file those financial disclosure statements, it's listed in the statute, elected state and county officials and school superintendents, even though they're selected or appointed by the county boards of education rather than being elected to the public. All members of state boards, commissions, and agencies appointed by the governor. So if you are on the Historical Preservation Society of someplace in Greenbrier County or something like that, or somewhere in Fayette, and you were appointed by the governor, you better check into it. You may have to file a financial disclosure statement every year. Secretaries of departments, commissioners, deputy commissioners, assistant commissioners, et cetera, et cetera, et cetera. There's a whole list. Again, if you're wondering, gosh, does that apply to me? Feel free to give us a call. You can speak with Rachel Carpenter, and she can tell you whether or not you have to file a financial disclosure statement, or you can speak with Ellen, or you can speak with Caitlin. Those are three geniuses who take care of that. And they're very good at it and very patient. So please feel free to give them a call if you have a question on that. And they're also good about helping you if you have a question about how to fill out your form, even if you know, well, you're going to have to. Sanctions. And now we're not talking about sanctions just for the financial disclosure statements. I'm talking about sanctions for any violation of the West Virginia Ethics Commission or West Virginia Ethics Act. Those sanctions could include a public reprimand. That means a press release goes out saying you're being reprimanded if you've been found guilty of something. Restitution, if you've wasted or misused money or equipment or something that the public owns, you can be required to compensate your public entity or the agency you work for what you misused. You can be fined up to $5,000 per violation. You will have to reimburse the commission for the cost of investigating your claim. Sometimes that's cost more than the actual fines themselves and the restitution. And the commission can make a recommendation that you be terminated from employment or removed from office. Now, we cannot terminate you from your employment, nor can we require you to be removed from office, but we can make that recommendation, and usually that puts the idea in people's minds. So it's not a paper threat. Now, I want to talk a little bit about the Open Meetings Act, and here are the various subjects we talk about, what kind of meetings, and we've already talked about a little bit of that in an answer to one of our questions on our chat function. What meetings are not subject to the Open Meetings Act, what kind of notice and agenda must be made, or what must be provided to the public for such meetings, when it's proper to go into executive session, what you need or have to put in the meeting minutes, and what can happen to you if you violate the Open Meetings Act. So let's go ahead and hop right into that. State, county, and municipal administrative and legislative bodies and any body that meets the definition of public agency are subject to the act. Committees or subcommittees of those bodies that are subject to the Open Meeting Act, if that committee is given the power to either take action or to recommend action, those are also subject to the Open Meetings Act. If there's a situation where a quorum of the governing body meets and it's on a matter in which quorum is required, and in order to make or deliberate toward a decision that requires official action. In other words, if you're taking up business, not only if you decide on some matter, but if you deliberate and talk and discuss it, where you do that must be in an open meeting. Now, that doesn't mean that if you have 5 county board members, for example, that 2 of them, and 2 out of 5 is not a quorum. It takes 3 out of 5. Can't talk with each other away from a board meeting about something. Maybe it's not a good idea, but it's not something that would make that gathering of 2 of these county board members, which doesn't constitute a quorum, to get together and talk about an issue. They can do it. Meetings that are not subject to the Open Meetings Act, a meeting or a gathering, I should say, we'll avoid the use of the word meeting, because when we say meeting now, we're talking about something that meets the definition under the Act. A get-together where logistical matters like where we're going to meet and what's going to be on the agenda and what time the meeting is going to be, it's things of that nature. Those gatherings are not subject to the Open Meetings Act. Adjudicatory meetings. In other words, if you might figure out from this that I used to work for an employment union that dealt with county boards of education. If a county board of education, for example, is having a hearing on the disciplining of an employee, and that's all that's on the agenda, that would not have to be noticed, and that would not have to be open to the public. The employee themselves can request and require that it be done in public. Same thing would apply to student suspensions, things of that nature. Other get-togethers where you have a quorum of, or a majority of the council or a commission or whatever, that would not be considered a meeting under the Open Meetings Act would be an on-site inspection. For example, if the county commission is having a new building put up and all of them get together and go out and just look at the building and see what progress is being made, that's not really considered a meeting. Now, if they start talking about something that's going to require action in the future, or some sort of official action, then they go across that line, and it probably should be a noticed meeting that's open for the public. But as long as they just go and view and take in information and don't deliberate, don't talk, don't vote on something, it's not necessarily a meeting. We also put down that political party caucuses are not subject to the Open Meeting Act, but that's not so much because it falls under exception. It's political party caucuses, even though that's kind of connected with government in a way, it's not really a public governmental entity. The Republican Party is not subject to the Open Meetings Act, or the Democratic Party. The Ethics Act doesn't apply to those people unless they're also public employees or public officials. Next area. Again, get-togethers or gatherings are not subject to the Open Meeting Act if we're just talking about general discussions at unplanned or planned gatherings for training or for some ceremony or similar settings. A good example would be if the county commission, if all three county commissioners end up at a picnic, they didn't plan to do that, but a quorum just happened to show up. And as long as they don't conduct any business or talk about any business that's coming up, then that would not be some sort of gathering that would constitute a meeting under the Open Meetings Act. Basically, this one doesn't really fall into a particular category, but I want to talk about it. The Open Meeting Act does not require that the governing body provide a physical meeting space, but only requires that citizens be given access to a meeting by telephone conferencing or other electronic means. In other words, you can have a public meeting, if it's open to the public, by Zoom or by Google Meet or something along those lines. People think that all that came in response to the COVID crisis, but actually the Ethics Commission had addressed those questions even before any of us had ever heard of COVID-19. And along those lines, we now go to the situation of what kind of notice is required. The notice must include the date, time, and place of the meeting, and it includes any committee meeting. And the Open Meeting Act, even though for whatever reason I left it off this slide, also requires that you provide the purpose or the agenda for the meeting. The statute itself doesn't say, but the commission has indicated that it's reasonable and for a meeting notice and the agenda for a regular meeting must be posted 3 business days in advance, and unless you have a group that meets on a weekly basis, in which case you're only required to post it 2 days in advance. If you have a special meeting, the notice must be posted at least 2 business days in advance. We're talking here about county and municipal governing bodies. If it is a state agency, there are additional requirements. They have to give notice within 5 business days or 5 business days before the meeting, and it has to be put on the Secretary of State's website. Here's an example from the Ethics Commission's website of the kind of notice that's necessary. In this case, we have set meetings once a month. And the meeting notice just has to go up to the beginning of the year. Of course, it stays on our website throughout the entire year. And the agenda, though, for particular meetings does come out, like I say, at least three calendar days prior to the meeting of the Ethics Commission. We often get questions about where do you have to post things? Do you have to put up a legal notice in the newspapers? Do you have to put it on your website? What's required? Well, as far as what the Ethics Act requires, if you're encouraged, of course, to put out press releases and widely disseminate the fact that you're going to have a meeting and when it's going to be and so forth. But actual requirement, you just have to post notice at a written notice at your principal place of business. If it's a county commission, wherever the county commission meets, or the courthouse. If it's a city council, it's the city hall. And basically, that's all it's required. Basically, you may be required to do postings in different places by other statutes. For example, I think county boards of education now are required to not only post the notice of their meetings at the county board central office, but they also have to publish it on their websites. Emergency meetings. What happens if something comes out and you just cannot wait 2 business or 3 business days in order to actually address the issue? Well, if you have an emergency meeting, you have to only give as much notice as you can. In other words, whatever is practicable. Of course, the restriction that kicks in is what constitutes an emergency meeting. It's been held that an emergency meeting means that something to address an issue where there's an imminent threat to public health or safety, or an imminent threat of damage to public or private property, or imminent material, financial loss, or other imminent substantial harm to the public agency or the governing body. In other words, if it's something that you have to either take it up now, or you're going to ruin, you're going to get a bunch of people hurt and killed, a lot of property destroyed, or something along those lines. But it does have to be a real emergency. And again, if you have a question about it, give us a call and we'll do our best to give you the guidance. The agenda is important. You can't take up an issue if it's not on the agenda. If something comes up, that you think needs to be discussed, you need to, if it's not on the agenda, you need to wait and put it on the agenda for your next meeting and go ahead and take up the matter at your next meeting. Agendas have to be relatively specific. It's not sufficient to just say old business, new business, personnel, opening bids, or something like that. You need to make it clear enough that a member of the public can tell what you're actually going to do. You don't have to forecast, give every little detail, but a good example, for example, instead of putting down personnel, you should use something like fill the position of office manager, or instead of opening sealed bids, open sealed bids for the city hall roof repair project, something that gives the public a notice of what you're going to be discussing, basically. Let's see if we have any further questions. Okay, here's a question I'm going to have to research, and that is if there's an in-person place where people can come in person to a meeting and it's being streamed live, and you try to listen to it online, and for whatever reason there's a technical glitch, and all the people who are online or on the telephone can't hear what's going on, or the sound is cut off. What affects it? I don't know. That's something that I'll talk with the other people, and we'll try to get an answer for you. I see the person. I'll get their information down here, and I'll contact them later to give them an answer to that question. Want to mention this, there is a Uniform Public Meetings During Emergencies Act up in 2023. We do not have jurisdiction over that, but a lot of people go to that thinking that it might tell them, what justifies an emergency meeting and so forth. Actually, that's kind of designed to indicate what a public body can do and during an emergency, like the COVID crisis we had, and I guess there are other things that can come up along those lines. Although, I hope none of them ever come up while I'm still around. But in any event, that's a little different. It's not when we have an emergency meeting. It's what if there is an emergency? How any kind of rules we have to apply to that. That's not something that we deal with. And if your question is the issue that we want to talk about constituted a reason for an emergency meeting, that is still governed by the Ethics Act, and you contact us about that. Big question we get a lot of times: what can a public body discuss in executive session? Okay, you can only go into executive session for the reasons that are permitted by the Open Meetings Act. In 6-9A-4, there are 12 reasonably broad, but exceptions that would allow a governing body to go into executive session to discuss a matter. They still have to come out in open session to actually take a vote to do something or not do something, but they can go in executive session for that. One of the big ones is personnel. We talked about that a little bit. The vote has to come in open session, but discussing what kind of action you're going to take, that can be done in executive session. The agenda need not mention that an executive session is anticipated. In fact, it shouldn't say an executive session is going to be held for sure, because executive sessions have to be made by motion to go into executive session, and it has to be subject to a vote. So while it's not required to mention that possibility at all, and it's perfectly acceptable to say we anticipate a executive session coming up, basically, you shouldn't put down that it is going to happen. The motion to go in executive session must identify the reason, and as I say, any votes must be taken in public. Here are some of the exceptions that are found in 6-9A-4. We're getting perilously close to 1 o'clock, so I'm not to go over those. I just will mention one thing that is a common misconception. People think about what is discussed in executive session automatically becomes confidential. Well, that's not true. If you discuss confidential information, like someone's medical history or something like that in executive session, it remains confidential. But if you're talking about something in executive session and there's not an agreement to keep it confidential, it doesn't fall into any other of the requirements of law for something to be maintained as confidential, the fact that it's discussed in executive session, it doesn't matter. We not constantly, but we occasionally get calls from people who say, gosh, we talked about this, and then so-and-so, one of our board members, went out and told everybody about it. Well, unless the matter was confidential, in and of itself, the fact that it was in an executive session discussed there doesn't make it confidential. Minutes, they have to have the date, time, and place of the meeting, the name of everybody who attends as a member, all motions, proposals, resolutions, and the vote that was taken, and but those main things. Often there's a question about how specific the minutes must be. That's up to the body. If you meet the actual requirements, the minimal requirements, then as far as the Open Meeting Act, you're in good stead. If you want to add additional information for the purposes of informing you the citizens who are subject to you, well, then that's a good thing, but it's not required. Here's something you can find on our website: sample minutes from a West Virginia Ethics Commission meeting. People ask, when are minutes required to be released? Well, the statute says within a reasonable time, and a reasonable time has been defined as 1 business day after the meeting at which the minutes are approved. So generally, if you have a meeting on day 1, then your next meeting is 10 days later. That next meeting is where the minutes from your first meeting are approved, and 1 day after they approve them, they should be available to the public. To request an advisory opinion on an Open Meetings Act question, you need to be a member or employee of a public agency. Well, actually, you need to be a member of a public agency that or official or a board member of the public agency that is subject to the Open Meeting Act. Somebody can't just ask us, I'd like to get a written advisory opinion on whether that county board of education over there or that county commissioner over there can do such and such at an open meeting or at a meeting. It has to be somebody from that. As far as complaints, as I said before, we don't take complaints on the Open Meetings Act because we're not allowed to. That goes to circuit court. Now, here you have West Virginia Ethics Commission, our written address, our phone number, and our general mailbox. And, you can send us queries either way. If you want to have a question that you want to talk about, that you don't want to do it in public, feel free to give us a call this afternoon or tomorrow or next week sometime, and we'll do our best to discuss it.